Yeah, it was a unanimous decision coming out of the Supreme Court, 9-0. So, says the unanimous Supreme Court made it easier Tuesday to bring lawsuits over so-called reverse discrimination, siding with an Ohio woman who claims that she didn't get a job and then was then demoted because she was straight. The justice's decision affects lawsuits in 20 states and the District of Columbia, where, until now, courts had set a higher bar when members of a majority group, including those who are white and heterosexual, sue for discrimination. So, hello, Julio. Ketanji Brown Jackson wrote the opinion. So the new Supreme Court justice, the one that Biden put in, that doesn't know what a woman is, said she's not a biologist. At least she can tell that discrimination is wrong. Said that civil rights law draws no distinction between members of majority and minority groups. No, I mean, it just kind of makes sense, right? By establishing the same protections for every individual without regard to that individual's membership in a minority or majority group. Congress left no room for courts to impose special requirements on majority group plaintiffs alone, Jackson wrote. The court ruled in an appeal from Marlene Ames, who worked for the Ohio Department of Youth Services for more than 20 years. So this is what even makes it worse, because I'm wondering if this is going to have any implications on, there was tons of lawsuits over the years coming from different police, people suing police departments and cities, fire departments, because they kind of did stuff that would be considered discrimination. They said, oh, what color are you? Or what, are you a part of, are you if you're female, if you're a minority, you get extra points on tests and stuff. And, that's basically discrimination. It is. So, says Thomas, joined by Neil Gorsuch, cited a brief filed by the American First Legal, a conservative group founded by Trump aide Stephen Miller, who's the guy that's always going hard at the left and the media. He's the bald guy, Stephen Miller, and he's he's a riot to listen to. It says to assert that American employers had long been obsessed with diversity, equity, and inclusion initiatives and affirmative action plans. 2 years ago, the court's conservative majority outlawed consideration of race in university admissions. Since taking office in January, President Donald Trump has ordered an end to DEI policies in the federal government and has sought to end government support for DEI programs elsewhere. Some of the new administration's anti-DEI initiatives have been temporarily blocked in federal courts. I would think those are all gonna get shot down eventually, but that his rulings are going to stand on it, because basically he's just saying you can't discriminate. So they're not saying to discriminate. It's weird that they could get a sue and say, no, you must discriminate. Federal agencies have moved quickly to implement Trump's vision and shift priorities to reflect that mission, including rooting out discrimination against members of majority groups, which all discrimination is wrong. The best way to stop racism is to stop being racist. The best way to stop discriminating is to stop discriminating. The head of the Equal Employment Opportunity Commission, responsible for enforcing workplace discrimination laws, has pivoted the agency to focus on eliminating all forms of race discrimination. Hello? Isn't that what they're supposed to do? Get rid of all forms of discrimination? That's the whole point? It shouldn't really matter. I mean, I don't know if I want to get into this really, but if you look at who's employed by our federal government, it's clear that there's been discrimination going on. That's all I'll say about that. At the same time, acting chair Andrea Lucas has moved to deprioritize cases involving discrimination against transgender workers, saying she rejects the idea that civil rights exist solely to remedy harms against certain groups. Jackson's opinion makes no mention of DEI. Instead, she focused on Ames' contention that she was passed over for promotion and then demoted because she is heterosexual. Both the jobs she sought and the one she held were given to LGBTQ people. Sounds kind of discriminatory. Title VII of the Civil Rights Act of 1964 bars sex discrimination in the workplace. A trial court, the Sixth Circuit Court of Appeals, ruled against Ames. The Sixth Circuit is among the courts that have required an additional requirement for people like Ames showing background circumstances that might include the LGBTQ people who made the decisions affecting Ames, or that statistical evidence or a pattern of discrimination against members of the majority groups. I am going to talk about that, Choosy, because I have some family members that are being affected by the smoke up in Illinois, and they, they have questions. I don't. I'm confused by the whole wildfire thing. I don't understand how this. I mean, I saw some of the pictures of the wildfire stuff, and I don't know how these fires that don't look like they're that big are affecting so much of the United States. Just seems weird, you know. So I can never forget you, Dan. Never. The appeals court noted that Ames didn't provide any such circumstances, but Jackson wrote, this additional background circumstances requirement is not consistent with Title VII's text or our case law construing the statute. So, yeah, so that was that case. So basically, they have ruled that any discrimination is against the law, basically, in hiring and employment, which the way that the law is written. So that makes sense. Can't argue with that.